advantages of a limited. Let's now look at lecture example 2 about a limited company. Phil is looking to set up a new business selling cars, and he's trying to decide whether to set it up as a sole trader or a limited company, but he's actually unsure what the differences are. What we need to do here is draft an email to Phil explaining what the main differences are between the two types of business. So we have the format of an email in our notes here, and it's addressed to phil@businessunknown.co.uk, and we are an accountant, so from an accountant. The date, we're not given a formal date, so we'll just say today. And the subject is what we're talking about. And here we're talking about different types of business. And this would suffice as your email header in your real exam. Okay, so we need to address who we're writing to. So, dear Phil. And in the real exam, what you'd do is you would structure your answer in a logical way. You would answer the question that has been set. You would use full sentences and good, appropriate language for the person you're writing to. Include no abbreviations, no slang. You really need to think about who it is you're writing to. Now, for simplicity purposes here, we're going to write a few notes to help us write the answer. After the recording, it might be a good idea to go away and attempt to write this out in full. So you would start with an introduction, and then you would go into the main body of your report. And what we're looking to do here is to state the differences between a sole trader and a limited company. So remember, we are just drafting notes here, ready for you to write this out in full. So, starting with a sole trader, there is no distinction between the individual and the business. A sole trader is a single individual, a one-man band. And what they've done is they've set up the business, they own the business, and they run the business. There is no separate legal entity, so for a sole trader, unfortunately, they are fully liable for any debts of the business. What they could end up doing is lose personal possessions. So, quite risky. One benefit of being a sole trader is there is no set format for accounts. And regarding taxation, they're taxed on income personally. So a few notes there on a sole trader. In comparison to this, a limited company does have a separate legal identity. Individuals have limited liability. Which means individuals are only liable for the money put into the business. and you are not personally liable. One of the main advantages of a limited company. So, for a limited company, the company can enter into transactions in its own name. It can own assets in its own name. It can have its own liabilities. Unfortunately, however, there are more regulations for a company, according to the Companies Act 2006. And financial statements are available for public view. Not only that, your personal details will be available for public view as well. A limited company will pay corporation tax rather than income tax. And easy transfer of ownership of company, no disruption. It doesn't matter if one of the directors retires. However, with a sole trader business, it does matter if they are retiring or unfortunately pass away because they take away their expertise and their knowledge with them. Now, do remember that these are simply notes. What I would like you to do now is, at the end of the recording, have a go at writing this out in full. Remember, good language, good structure, no abbreviations or slang, and think about who it is you're writing to. Once you've done this, refer to page 30 for the full answer for you to read through. Welcome back. Having looked through the detail of sole traders, partnerships, and companies, we may now need to form a company. So we're looking at company formation. The procedure for registering a company is as follows, and there's a big list of stuff that we have to do. What we need to do is we need to submit certain documents to the Registrar of Companies, and these are at Companies House. What we need to submit is the proposed name of the company. Now, there are certain names that you're not allowed to have. Have a think of the rudest word or name that you can think of. Got it? Right, you can't have that one. And we'll look at more about this in a future recording. So we'll include the proposed name. We'll also include the fee because there is a cost to establish a company, so we'll need to send that as well. We also need to state whether the registered office is situated in England and Wales, or just Wales, or just Scotland, or just Northern Ireland. It's the concept of domicile. What rules are we bound by? And this is determined by the place where we're registered. You also need to submit a statement of the intended address of the registered office and whether the liability of the members, the shareholders, is limited. Limited liability, as we've mentioned previously. And also whether this is limited by shares or by guarantee. And most of the time, it's limited by shares. We also need to state whether the company is to be private, so this will have the initials LTD or the word limited after the company name, or if it's a public company, and this will have the letters PLC after it. If limited by shares, then we need to state what is the share capital in the statement of capital. We also need to state who owns it, so the initial shareholdings. For example, it might be Fred has 5 shares, Narinda has 20 shares. And then we have 2 documents that we need to submit, and these 2 form the constitution of your company and your dealings with outside of that organisation. So we have the Articles of Association and we have the Memorandum of Association. The Articles of Association, you don't have to use your own, you don't have to draw your own up. You could use the model articles, and these are provided in the Companies Act. We also need to submit a statement of proposed officers, so who the directors are, and if a company secretary is needed, the details would be there as well. And this would be adding on the service addresses, so where any legal documentation should be sent. You also need a simple document, the Statement of Compliance, which we'll see in more detail soon, and this states that all requirements of the Companies Act have been met. So there's lots to do. It's a bit of a faff. So what you could do instead of starting a company from scratch with company formation, you could go to a statement of a firm of solicitors or a firm of lawyers, and you could buy what we call an off-the-shelf company. These types of company are a bit like, here's one I made earlier, a bit like Blue Peter, if you're old enough to remember Blue Peter. So we say that you're buying a company off the shelf. It means that the company has already been registered with Companies House, so no need to send all those bits and bobs in that we saw earlier. They're ready-made companies and they're available for immediate use, so very quick and easy to set up. They already have an existing company number. But there are a few odd things that you need to do. What you must do is change the register of members, so the detail of all the shareholders or members. And what you could do, you don't have to, is change the articles of association, the company name, and anything else. And all this can be done electronically now. No need for that postal system. Now, once the Registrar of Companies is happy, what they will do is they will issue a certificate of incorporation, and the company's life commences from that date. This is the important date. It's like the birth certificate of the company. Private companies can commence trading from this date, which is fantastic. Off you go. And this is better than a public company because there's more hoops that you have to jump through for a public company. The certificate will state on it the name of the company and also the registered number of the company. And the purpose of the company number is that people can find you easily on the Companies House website. It would also state the date of incorporation, because this is the birth certificate of the company. It's the important date. It's the date on the certificate, the date that the company came into existence on that day. It's like a happy birthday date. You'd also state on there whether it's a limited or an unlimited company. Most will be limited. And if it's limited, whether this is by shares or by guarantee. And most will be by shares. You also have to state if it's a PLC, a public company, or a private company with the letters LTD. It will also state whether the registered office is either in England and Wales, or just Wales, or just Scotland, or just Northern Ireland. So that was all about company formation. Hi. In the previous recording, we saw the procedure for registering a company. There's lots of information, lots of documents that must be sent to the Registrar of Companies at the company's house. So let's say you have done this and you are waiting for everything to be agreed and your certificate of incorporation to come in the post. Before this time arises, before the company is incorporated, the business might need to enter into contracts, perhaps contracts for getting stationery, entering into contracts to have a physical premises and to hire staff so the business is ready to go and start operating as the formal company. But because a company doesn't exist yet, because it's not incorporated yet, anything before that time is called a pre-incorporation contract. Let's have a look at the timeline here. And let's put a cross here. Let's say this is the date of the company being incorporated. Now, this highlighted time period, everything before this point in time would be a pre-incorporated contract. And it says in the notes here we do need to be very careful with pre-incorporated contracts because in reality, if the company doesn't exist yet, then it can't possibly sign a contract and be bound by that contract. A pre-incorporation contract is defined as being a contract made in the name of the company, but before the company comes into existence. It has no legal capacity to enter into contracts. So the following will apply. The company cannot step into the shoes of the contract because it didn't exist when the contract was made. The company is not bound by the contract. It doesn't have to fulfill its end of the deal because legally the company doesn't exist. The company cannot enforce the contract against the other party, once again because the company does not exist at the date of the contract. The person who entered into the contract, and this person is known as the promoter, will be personally liable for the contract. It will be nothing to do with the company because the company was not formed at the time of signing, and this is defined in the Companies Act. It's the promoter's responsibility. It's the promoter who sets up the company and sorts everything out that's required. They're the ones who sign the pre-incorporation contracts on behalf of the company because the company doesn't exist. So they'll be personally liable if things go wrong. The promoter would also have the right to personally enforce contracts that they had entered into. What a promoter needs to do is to try and protect themselves. So they could try and not enter into contracts until the company's actually been incorporated, and then it will be the company's responsibility. What they could do instead is use an off the shelf company so it's ready to go, and we saw that in the previous recording. They could agree a draft contract only on the basis that it will be signed once the company has been incorporated. Let's have a look at lecture example 3. Paul lent £10,000 for the business of a company to be called Music Management Limited. And this company was to manage a new boy band called Take This. Louis signed a letter promising repayment for and on behalf of Music Management Limited, but the company was never formed because the band actually split up. What we need to do here is answer the question, what is the legal consequence of this contract? And we need to select one answer. Now, the things that stand out to me here is that Music Management Limited is not incorporated yet. It's going to be at some point in the future. Not incorporated yet. So from what we've just seen, pre-incorporation contracts are really the responsibility of the promoter. The promoter here is Louis, and he will be personally responsible for what he's signed here. So we have a pre-incorporation contract. So option 1 here, Paul cannot make any claim for his money back because the company doesn't exist. Well, Paul can actually claim because there is a contract, but the contract would be with Louis, who is the promoter, rather than with the company because the company doesn't exist. So this one is not correct. He can make a claim, but it would be from Louis. Our second option here is that Paul can sue Louis to recover his money. He's lent £10,000, and this is the correct option. Louis is the promoter, so he is personally liable. So you need to be very careful if you're a promoter. And the final one is that Paul can sue. Well, yes, he can sue, but who can he sue? The band members. No. He can sue, but not the band members. He would be suing Louis. When forming a company, we need to register the company with the Registrar of Companies at Companies House. And as part of the process, what we need to do is submit the proposed name. When considering business names, there are certain rules and regulations that we need to adhere to. For a company, the words limited or LTD can be used for a private company. You can choose which one you would rather use in the name. If you are a public company, the name must end with PLC. It's still not a free for all. A company name cannot be the same as a name already used. So I could not call my own personal company First Intuition because one exists already. Company names are also not allowed to be offensive, and this is offensive in the opinion of the Secretary of State. So, for example, I couldn't choose a company name of Hookers Limited or Prostitutes Limited. Believe it or not, these were real world cases. Company names can also not be illegal. So if you are not a bank, you cannot have the word bank in your company name. If you are not a dentist, you cannot have the name dentist in your company name. This is very similar with the blood donor centre. You couldn't have that in your name. You can also not have a name that requires consent from the Secretary of State unless consent is given. So if it's relating to size, for example, I couldn't name my company's Nicholas International. That would not be permitted because I operate from a small premises in Leicestershire. You need to be careful not to imply you're bigger than you actually are or have associations that you don't actually have. In a similar way, sensitive names. So, unless you are royal, you cannot use the name royal in your company name. I can't call myself Nicola Royal. This isn't just for companies, but it also applies for sole traders and partnerships as well. It's important to choose a good name because the company name gets displayed absolutely everywhere. Inside the registered office and all places of business, on all business letters, notices, and official publications, on cheques, orders, receipts, and invoices. And this just makes it really clear about who it is we're dealing with. So let's say you've submitted your proposed name of your company. It's gone to the Registrar of Companies at Companies House. At some point, you may be required to change your business name. Perhaps if an error has been made. Perhaps if it's the same as another company name or too similar to another company name. Perhaps they accidentally gave it to you and it's their mistake. The company name would have to be changed within 12 months after registration. Some direction here. The same as names would include where there is just certain punctuation that's different, certain special characters that are different, a word or character that's similar in appearance or meaning from the existing one, a word or character used commonly in UK company names. So, as an example here, Hands UK Ltd and Hand apostrophe S Limited are the same as Hands Limited. So that would not be permitted. You can only register a same as name if your company is part of the same group as the company or limited liability partnership. You can use it if you have written confirmation that the company has no objection to your name. So these were all same as names. There are also two like names, and these are defined differently. You may have to change your name if someone complains and Companies House agrees it is too similar to a name that's already been registered and it was registered before yours. The example here, Easy Electrics for You Limited, is the same as Easy Electrics for You Limited. Sounds exactly the same, it's just written a little bit differently. Welcome back. Let's now put into practice what we've learnt in lecture example 4, which is about a new company. Adil and two business associates wish to start trading through a company. They have chosen a name, the Royal Trading Company, and are ready to go ahead. They are looking to incorporate a company limited by shares, but would rather not include Ltd in the name. They are not familiar with the necessary procedures and have asked for some information. So, a few things spring to mind as I was reading through this one. It does say they've chosen a name, the Royal Trading Company. Now, we don't know this, but I'm guessing they are not royal, so not permitted in the name. They are also limited by shares. So, as a private limited company, they must have Ltd or the word limited at the end of their name. The rules that need to be adhered to. Let's now have a read of the questions that we need to answer. In part A, in seeking to form a company, Adil is acting as what? The first option here is a director. Now, a director manages a business, an organisation, on behalf of the owners, the shareholders, also known as members. So this isn't the correct answer. The second one we've got here, an officer. Well, the officers are the directors and, if applicable, the company secretary. So this would not be the correct answer either. The third one, a promoter, is the correct answer. A promoter is responsible for setting up the company and sorting out everything it needs. They're the ones who sign pre-incorporation contracts on behalf of the company. They're the ones who will send all the information and documentation to Companies House. So the correct answer is a promoter. The final one, the shareholder or members, these are the people who own the company and they would have nothing to do with setting up a company. So the incorrect answer there. In part B, it's asking us where the application to form the company needs to be submitted. And I can see immediately it's the Registrar of Companies located at the Companies House. It would not be the Department for Business, Energy and Industrial Strategy. It would not be HM Treasury, this is our taxes, and it wouldn't be a bank. And finally, in part C, which of the following will apply to the chosen company name? And we've annotated quite a lot on the scenario already as it sprung to mind. What we need to do here is pick two. In our first option, it will not be acceptable to use royal in the name without special permission to do so. This is one of the correct answers. We cannot use the name royal, we cannot use the name charitable unless it is correct. The name must include PLC. No, not correct, because it's limited, a private limited company, so it must have either the abbreviation Ltd or the word limited at the end of the name. The final option here, the name chosen will not be allowed because it's offensive. Wow. Okay, let's revisit that name. Let's have a look. Does it cause offence? The Royal Trading Company. I don't think that's offensive, not at all. It's not like we spoke earlier, the Prostitutes Limited. So, incorrect, the final one. That concludes our recording. In previous recordings, we have seen the detail of sole traders, partnerships, limited companies, and not for profit organisations. We've also seen how we need to register and form a company with Companies House. Now, once a company has been incorporated and we have a certificate of incorporation, there are statutory books that the Companies Act say that we have to keep. So, statutory books according to the Companies Act. And these are usually kept at the company's registered office. Let's have a look at these statutory books. The first one is a register of the directors and the company secretaries. So the contents, what's included in this would be the name of the directors, their addresses, date of birth, nationality, occupation, and if they hold any other directorships. We also have to have a register of members or a list of shareholders. How many, where, and when. Quite a recent amendment is a register of people with significant control, and we call these PSC. So, what is this word significant control? Well, significant control means having more than 25% of the shares or the voting rights, and also the ability to appoint or remove the majority of directors. According to the Companies Act, we also have to keep minutes of general meetings. Now, general meetings are different to board meetings. These are meetings of the shareholders where important issues are discussed and voted on. So, as well as business records, we must also keep accounts. And these are listed down the page. We have annual financial statements, accounting and tax records, and a confirmation statement. And we'll look at each of these. So, our annual financial statements, first of all, these are annual accounts and they are addressed to the shareholders. The members of the company, the owners of the company, because they own the business and they want to see the performance of the company over a period of time. So it's for the shareholders, and because of the owner management split, the management, the directors are the ones that have to produce the financial statements. They run the company on the behalf of the shareholders. And these financial statements are presented to the members in the general meeting. What we say here, and you may have heard of the expression, we're laying the accounts before the shareholders. And these have to be filed at Companies House. Depending on if you're a PLC or a limited, it's 6 months for a public company or 9 months for a private company. Again, it's tougher being a PLC. Now on to the accounting records. Accounting and tax records can take many forms. They can be manual records, they can be spreadsheets, and they can be integrated accounting software, for example, Sage. The records have to be sufficiently comprehensive to show and explain the company's individual transactions. They must be able to demonstrate cash in, cash out, for example, where cash has gone to. And there are statutory minimum time periods that they have to be retained for, and this is both for legal reasons and tax purposes. One thing to note is that shareholders have no right of inspection of the records. Our members, our shareholders, they don't get to see, for example, the cash book. What they do get to see is the annual accounts instead. They don't need to know where all the numbers have originated from. And finally, we have to have a confirmation statement. This used to be called an annual return, so some people still refer to it as an annual return, but it's now called the confirmation statement. All companies must electronically confirm the details held by the registrar at the company's house at least annually in this confirmation statement. We need to ensure that all the records about the company are accurate and up to date as well. It's quite flexible, whenever you like, really. There is no set date, but no more than 12 months must elapse between incorporation and the first statement, and then between confirmation statements as well. It's a rolling process annually. And the details held here, what we're confirming, would be the details of the registered address, share capital, who the shareholders, the members are, who the directors, and if applicable, the secretary. So that's our confirmation statement. Hi, welcome back. In our previous recording, we saw the various different business records that companies have to keep as statutory books under the Companies Act. We looked at annual financial statements, accounting and tax records, and also confirmation statements. Now, rather than doing everything through the postal system and relying on Postman Pat, we now can file things electronically, and that's what this recording is about. Traditionally, businesses would have a manual filing system that consisted of large metal filing cabinets placed around the office space. Documents may have first been filed by document type, for example, if it was an invoice or a credit note or a goods received note, and then filed in alphabetical order. A lot of drawbacks with this system. Me, 25 years ago, during the university summer holiday, I worked in an accounts department of a large retail chain head office, and their filing was sorted exactly like this. It was extremely time consuming. Things could be filed incorrectly. Paperwork could be lost, it could be dropped on the floor. It took up a lot of valuable office space. And security could be questionable. So, advances in technology have actually made the process of filing so much easier. Why didn't they invent this earlier when I was working in the accounts department? Things have moved so quickly with technology. Software solutions will help a business now to capture, store, retrieve, and process documents and data and information in a more effective and intuitive way. So, human error can be avoided through the use of version control. Duplication can be avoided as well. There's also the advantage of speed of access. In the notes here, it says that electronic filing ensures that the right people have instant access to what they need and also when they need it. And controls can be put in place to protect documents from those that shouldn't have access to it. So things like antivirus software, locking screens and having passwords on laptops, having policies and procedures in place and various access levels, having physical security like security guards and swipe cards, and we have encryption as well. Really important nowadays because we do have to adhere to data protection legislation. So let's have a look at the benefits that are documented in the notes here. Creating the idea of a paperless office because everything is stored electronically. So space is saved, there's a reduction in the need for those big metal filing cabinets, and there's a reduction in the paperwork. It also protects the environment and can help save money. It's an office of the future, as data is on a digital format instead. There's increased productivity because, as we've mentioned before, quicker speed of access to documents. Time is saved and can be used better in other ways. Reduced human error that we've mentioned earlier, and increased security. So that was about the filing of documents, but what about communications with the formal authorities? Well, instead of using the postal system with HMRC and perhaps Companies House as well, we can do everything online now. So instead of a paper based envelope with a stamp, we can now click a button and it will zip off to the correct place. Numerous advantages here. Instant communication online, no delays using the postal services. Information will not be lost, can't be lost in the post, things aren't dropped automatically. There is an audit trail through document versions, so you can go online and you can see a history of tax payments made year on year. It's easy to find and easy to trace, and you can also track progress of various applications. The main one here, it's secure and it's confidential. That brings us to the end of the recording. Welcome back. We're now going to look at the legal system. We're going to look at where our laws come from in the English legal system. Now, we don't need to know in detail all the information here, as we're training to be accountants, not lawyers, but we do need to understand the basic principles underpinning our legal system. So, we'll look at the English system, the courts, tribunals, and our main sources of law. Under the English legal system, law is defined as the system of rules which a particular country or community recognises as regulating the actions of its members and which it may enforce by the imposition of penalties. Where do our laws come from? We have common law and equity. We have private law and public law. And we have criminal law and civil law. And we're going to look at each of these in turn, starting with common law and equity. These are two separate things, common law and equity. With common law, this is judge-made law, and it's also known as case law. The common law is a set of rules common to the whole country, and these were established back in 1066 across the land. As we've mentioned already, it's also known as judge-made law or case law. With case law, it's the ruling of judges, and there's two things here, common law and equity. Common law arises from judicial precedent, and the aim is consistency. So we must follow the rules of the land, and if not, we may go to court. And judicial precedent is something you need to be aware of for your examination. It means that courts are expected to make decisions that are consistent with those of previous judges. We're following the rulings of previous judges. And you may have heard about a phrase that's used, a precedent has been set, which essentially means we have to follow the rules that have been set previously. This ensures consistency. So, the aim of common law is consistency and certainty. If two identical cases went to court, the same verdict should be reached by following the precedent that has been set in previous cases. There are drawbacks, however, with common law. No two cases are identical, so it could mean that common law becomes harsh and inflexible. Another problem with common law is that the only remedy available for the injured party is damages in the form of money, in the form of compensation. To rectify, we have something called equity. We use equity to improve case law, and this was introduced in the 13th century. It's a set of principles that were developed after common law to be a gloss on the top of common law rules and to improve common law. And the aim of this is to ensure things being more fair and more moral. Equity introduced new remedies, so rather than just having compensation in the form of money, other things are available as well. Specific performance could be required. There is an obligation here to do something. In the notes it says this requires a party to perform a certain act. You're made to do something. So perhaps there was an agreement initially to sell some land, and if they agreed to do it in the first place, but now going back on it, you wouldn't actually want compensation and money in the form of damages. You would want the land because it's more fair. Another remedy under equity is an injunction, not doing something. In the notes here, it says this can force an action or prevent it. So, for example, an injunction to not cut down the 80-year-old tree. You want the tree, you don't want pounds as compensation in damages. There's also rescission, which is restoring. And what you're doing here is putting the party back into their pre-contractual position. Judges will apply the principles of equity if the common law proves inadequate. Now, case law or common law and equity are like cake and icing. So let's have our cake here. Here's our cake. And here's our icing on top. So the cake here represents common law, and the icing on the top is that little bit extra. That's the equity. You can have a cake with icing, which is common law and equity. You can have a cake without icing, where you just follow common law. But you can't just have icing. You can't just have equity. You only get an equitable remedy if common law does not solve the problem. Let's have a look at lecture example number 1. Complete the sentence below by selecting the correct option. So we want one correct option here. In the event of a conflict between equity and common law, which one would be correct? The first one here is that equity prevails. And this is the correct answer. Common law was established back in 1066, a very, very long time ago. So if the outcome reached via common law seems unfair, then equity does prevail. So it's not that common law prevails. The third option here is a case is referred to the Court of Appeal. This is not the correct answer. This is a Court of Appeal is for more complex court cases or for appeals if decisions are believed to be wrong. And the final one here, an injunction is created, is not the correct answer. This is one of our 3 remedies under equity.